Hello everybody, my name is Professor Charles Szymanski. I'm from the University of Białystok Faculty of Law, and I'm going to give a short lecture on legal English. Many of you may want to learn legal English for a variety of reasons. Some of you may be planning to work in English-speaking countries, or you have contact with English-speaking businesses or law firms. But I'd like to also think that it's for general knowledge. Even if you don't directly work in London or New York, or you have a translation business, it's still probably a good idea to know professional and legal English to improve your everyday work life and even personal life to understand these terms. Finally, I think it's a key to understanding how common law systems work. As we see in the map before you, that there are a number of countries that have common law systems, and we'll talk about what that is in a moment. Essentially, it follows the old British Empire. So we look at the United Kingdom and Ireland and Europe, but also Australia, New Zealand, most of Canada, and most of the United States have common law systems. And so by learning legal English and understanding the basis of a common law system, you'll also learn more about how the legal systems work in these English-speaking countries. What is the common law? It's not such a simple question, but there are some key principles and terminologies and concepts that I want you to become familiar with. The first is precedent. In common law countries like the United Kingdom and the United States, the law is based on precedent. Precedent is judge-made law. Judges have a very key role in common law societies, and when they make decisions, depending on the hierarchy of the courts, other courts have to follow their decision. Sometimes this is known as, in a Latin phrase, stare decisis. It's a final decision, and lower courts in common law systems have to follow these decisions. So even if a future judge disagrees with what a court in the past has said, if that court is a higher court, for example, a court of appeals or Supreme Court, the lower court is bound to follow it. They have to follow it. And this is how the law develops. Basically, the law is settled by court decisions, but it also has an opportunity to evolve. And to understand that, you have to understand these two terms, binding and distinguishable. So when a court makes a decision, only one part of it is really binding. In other words, another court has to follow it. This is called the holding. This is the key legal issue that the court had to decide to resolve the case before it. It's called a holding. That is binding on future courts. However, as I told you a moment ago, the common law is not a static system. It's not frozen in time. And it does evolve, and a key to that is when you could show a case is distinguishable from a prior precedent, a previous case. What is distinguishable? It means that the case is meaningfully different than the case before it. And as a lawyer, if you could show that a case is distinguishable, your case is distinguishable from a prior case, then the prior case is not binding precedent. In other words, you've shown to the judge that it's a different case, and the judge could make his or her own decision on how it should be resolved. So the key concepts of the common law systems are precedents, what is the holding, because that part of it would be binding, and then as we progress, as there are more and more cases, a key job of the lawyer or advocate is to show that their case perhaps is distinguishable if they want a different result, and if you're on the other side and prior decisions are favorable to you, you want to tell the court and the judge that they're binding. Some basics, now that you've gotten some general information about how the common law system works and the key terms there, I want to tell you about terminology in the legal profession. And it does get a little bit different depending on what common law or English-speaking country you're in. I'll speak first from an American perspective. Most legal professionals who have a law degree, who have a license to practice law, They're simply known as lawyers in the United States. So the term lawyer would suggest that you do have a license to practice law and you have a qualified law degree. Esquire is a terminology, or a term that is used often in correspondence from American lawyers. So they may sign a letter, Charles Szymanski, Esquire. That would indicate that I'm a lawyer and that I have a law license, and sometimes that's abbreviated ESQ, period. So if you see that in a letter, that usually means that you're dealing with a licensed lawyer in the United States. Sometimes also, and this is maybe more informal, lawyers are called advocates. But the better term would probably be, at least in the United States, as a lawyer, to call these people lawyers. In the United Kingdom, it's a bit different. There are barristers and solicitors. Barristers are bringing cases to the court. They're arguing before the court. They are what you would call in the U.S. a trial lawyer, right? Going to trial. While a solicitor would be more doing documents and paperwork. That would be the key difference. So in the United Kingdom, the legal profession is divided in that way between barrister, those appearing in court, and solicitor, those who are dealing with contracts and paperwork. There are also some important terms that you need to know about who you're dealing with at, for example, a law firm. And these terms could be helpful to you. A sole practitioner would be a lawyer practicing individually. He or she has their own business, and they would be known as a sole practitioner. A partner in a law firm would be somebody of usually more senior status, and they would have an ownership interest in the law firm. So when you're dealing with a partner, this is a more seasoned person, a more experienced person, and they have a business interest in the law firm and usually an ownership interest. An associate, on the other hand, is simply an employee of the law firm. They would have a law license, a law degree, but they don't have an ownership interest, and oftentimes they would be younger or not terribly experienced. You may have associates with some higher levels of experience, but more or less they are younger attorneys with not as much experience, and they don't have an ownership interest in the firm. A senior associate would be someone who's not a partner yet, but they could have 10 or 15 years of experience, but for whatever reason, they haven't attained that level of partnership. Of counsel, if you see that indicated on correspondence or an email, what does this mean? It means that it's usually an older attorney or middle-aged attorney who is not a partner in a law firm, but has so much experience and such a wealth of knowledge that they have this special status. So they would be above an associate, but not a partner of the firm. And it's just to recognize that this is a person with special experience, maybe 20, 30 years of experience, and it gives them a bit more prestige. A non-equity partner is interesting. It's something perhaps above a senior associate, but they don't have a financial interest in the law firm. So it's really more symbolic. They're able to call themselves partner even though they in fact don't have an ownership interest in the law firm. There are various legal terms for public officials. Judge is someone obviously who's deciding the case. You might call them Your Honor, for example, or simply judge. Sometimes they're referred to in the third person as may the court do something. So you're referring to a judge as the court itself. A prosecutor is usually involved in criminal matters, bringing cases against accused criminals. In the United States, sometimes they're also known as district attorneys. That would be like a head prosecutor. And sometimes in the United States, these positions are actually elected by the people. They're not appointments. A law clerk is usually, in the United States legal system, someone who assists a judge. And it's usually a quite prestigious position. So this is someone out of law school that helps the judge write their decisions. This is distinguished from a clerk who may be an administrative function at a state or local or federal court. So this would not be as high a position as a law clerk. A U.S. attorney is most often in the United States system, which is a federal system. This is a federal prosecutor. A magistrate is a lower level judge. Sometimes these are elected. They could deal with some traffic problems or very minor issues. And so it is a kind of judge, but of a lower status. In legal education, there are various terms to describe what a law professor is. Often, at least in the American system, sometimes colloquially or generally, everybody who teaches at a law school is known as a law professor. But in a more formal sense, a law professor would be somebody at the top of their profession. In the American system, someone who has achieved tenure, so they would have a full and permanent position at a law faculty. They couldn't be removed except in exceptional circumstances. An associate professor is someone mid-career as a professor at a law school, and an assistant professor is really a new professor, someone who's just joined the law faculty, and often they're younger. An adjunct professor is a part-time professor, essentially, and many law schools use these to get experienced or specialized lawyers in the legal community, and they may teach a course in their area of expertise. Paralegals are assistants. They are not lawyers, but they do help draft documents, for example, under the direction of a licensed lawyer. And we've talked about law clerks who work for judges. There are some specific terms in criminal and civil procedure. The complaint begins the process, whether it be a civil case or a criminal case. Afterwards, in the civil context, there are various sometimes requests made to the court. A motion. A motion is a request to do something. So when you have a motion to dismiss the case, you're asking the judge simply to get rid of the case. In most times, the complaint is followed simply by an answer. And so someone has complained that you've done something illegal, you violated the law, and the answer is often you've denied that. You simply have not violated anything. In the American system, there is a big process after there's a complaint and an answer. It's called discovery. There's oral discovery and written discovery. Oral discovery is mainly focused on depositions, and the verb is to depose a witness. This is simply a private process to get information from witnesses about the case. They're sworn in, they take an oath to tell the truth, but this is not in a court. This is often in a lawyer's office, and they simply have to ask questions that are relevant to the case. And the general rule is almost any question that could lead to additional evidence is relevant. Written discovery is a variety of things, getting written documents that could be related to the case. The most significant of those would be interrogatories. This may come from the word interrogate, right? So you're asking the other side some specific questions about what they know about the case. You would do this before the oral discovery, before the deposition, so you have information about what a witness or what a party said. So there are written questions to a party, to a witness, that leads to additional information about the case. A request for production of documents is simply to get documents that a party may have about the case. So if it was a simple car accident case and you claim you were injured, these may also be medical documents. What injuries did you suffer? What's your prognosis? The common law systems often have a jury. A jury is theoretically your peers from the community, people who live in your community, and that could be defined broadly or in a narrow sense, and they decide the facts of the case, not the judge. Essentially, the jury decides who wins and who loses the case on the facts. Judges decide legal issues. In the trial, in a common law system, cross-examination, after one side has directly examined their witness, they've asked them questions, cross-examination gives the chance for their opponent to ask the witness questions. Many times you must have seen in films, there are objections. This is important in common law systems. The jury are not legal experts. They don't know the law. And so if they've gotten some information or the question is improper, they may not supposed to hear that kind of information or consider it. In that case, a lawyer may raise an objection. This could be especially hearsay. I've told you what John has heard from Mary. They don't have direct information about it, so you might have heard hearsay. This is an objection. The jury deliberates once they've gotten all the information. That means they think about who should win, who should lose the case, and then they would issue a verdict. Basically, this is a decision about who wins and who loses. If it's a civil case, they would also decide how much money or what damages should be awarded to the winning side. If you lose, there's the possibility to an appeal, and procedurally, this is often a notice of appeal you file with the court. That's just indicating that an appeal is coming. You could ask the judge to reconsider their case, to change his or her mind and get a new trial, but this would rarely be granted. Just very briefly, I'd like to just talk about some terminology and key fields. And again, I want to highlight the difference between American and British English. Corporate law and company law are talking about the same thing. It's essentially a form of business law, and we're looking about how corporations are constructed and what rules and regulations they have to follow. They are legal persons, but they're not actual persons, and sometimes that leads to different legal principles being applied. Family law has some basic issues that most of you are probably aware of, and divorce I don't need to explain further. Some specific issues or linguistic terms would be a prenuptial agreement, when the parties agree between themselves, often when they have a lot of resources, they're quite wealthy, how to distribute things in case they get to divorce in the future. So this is done before the marriage, and it anticipates, unfortunately, that the marriage may end, and the parties agree beforehand how the assets will be divided. Labor law has a different spelling in American English and British English, so be aware of that. Some key terminology there is termination or discharge. That means you're fired, that your employment is ended. Another key distinction in British and American labor law in terms of terminology is layoffs and redundancies. Layoff means you've lost your job through no fault of your own. The company has had an economic downturn, and therefore your employment has to end. This is called being made redundant in the British system. Criminal law also has its own special terminology. An indictment basically could be from a grand jury. A grand jury is a group, again, of ordinary people who decides if the prosecutors have enough evidence to go forward with a particular case. That's just an overview of some of the key principles and some key terminology in legal English. I hope it's been useful for you. I thank you for your attention, and I invite you to further lectures online, and I hope they will be as rewarding as this one in legal English. Thanks again.